Namaste and welcome to a brief overview of share capital. This is part C video and we will be covering employee stock option, global deposit receipt and change in capital in the course of this video. Please refer part A video for capital and rights and part B for premium and discount, further issue of capital, sweat equity and bonus shares. That brings us to the employee stock option. Companies are issuing option to buy shares in the company at a concessional price. We have seen sweat equity is issued at a price lower than the normal, and even the stock option to employees is issued at a price lower than the normal. It is price based on the valuation. The whole logic behind employee stock option is to motivate the staff and to retain staff, reduce staff turnover. This is covered under Rule 12 of the rules of 2014. Let's have a look at it. A company can issue shares as employee stock options approved by shareholders. Once again, because when you issue additional shares, the shareholders existing will be affected. Therefore, they should pass a special resolution. To which employee? He has to be a permanent employee. He could be a director, but he cannot be an independent director. And he could be an employee of a subsidiary. Whatever we used in sweat equity, it could be used here also. He could be an employee of a holding company also. But he should not be related to the promoter group. Even director, he should not be related to the promoters group. Or he should not be related to one who holds more than 10% of equity shares of the company. Employee stock option is to employees or directors. Approved by shareholders, permanent employees, directors, and not related to promoter group. What will you do? Once again, when you issue under a special resolution, when in doubt, ensure you disclose in an explanatory statement number of stocks, classes of employees, what is the appraisal process in deciding the value. The shares are to be valued before it is given. The scheme has to be assessed. Now, there will be three stages. There is a stage of granting. There is a stage of vesting. And there is a stage of exercise. What happens is, as per the agreement, an employee will be granted the shares at completion of an X amount of service. That is the stage of granting. He has got an option to buy the shares of the company. But that grant becomes his right to exercise after a specific period. And that duration is called the vesting period. Once it vests in him, it becomes his personal right to buy those shares. Grant vests. Once it vests in him, when it becomes his right, he can exercise his right to buy and he can take his time. And that period is called exercising period. Means the share moves from grant to vest to exercise. Till it vests in him, the right has not yet crystallized. Once it vests in him, it is crystallized with him, it cannot be withdrawn, he can exercise. If he doesn't exercise, there are details to be looked into. We will just have a look at it. The requirements of vesting and the period of vesting has to be specified. Period of vesting. What is the time required from grant to vest has to be decided. It should be a part of explanatory statement. Maximum period within which it has to be exercised, vested. And when he buys, what is the price at which he should be paying the company? And what is the formula based on which it is arrived? And what is the process of exercise when he buys his shares from the company? And after he buys, what is the lock-in period? An employee cannot just buy the shares and then offload in the market, because there will be a difference between the price. What you get as an employee is far different from what is prevailing in the market. But the company says, or the explanatory statement should state, what is the formula for exercise price, what is the process of exercise, and then what is the lock-in period. This detail has to be indicated in the explanatory statement. And it should also state the explanatory maximum number of options to be granted to an employee and how the options have been valued, what are the conditions for vesting, and when it can lapse in case of termination of employment, his right to exercise the option of buying shares. The specified time period within which the employee shall exercise the vested options in the event of a proposed termination or resignation of the employee. And the entire scheme has to follow the applicable accounting standards for presentation and accounting. Revisit. The explanatory statement talks of the details of the scheme, the process, period of vesting, maximum period for vesting, exercise of price or formula which is used, and what is the lock-in period, what is the maximum period allowed for options, number of options, method used to value, conditions of vesting, and what is the maximum period available for exercising, what happens when the person is terminated, and what is about the compliance with the accounting standards. These are to be available in the explanatory statement. And to take some more conditions of it, the company is granting option to its employees will have the freedom to determine the excise price. And it should be the excise price which is decided by a formula has to be as per the accounting policy. Special approval of the shareholders is required when the employee belongs to a subsidiary or holding company, and special approval is also required when identified employees during any 1 year will be offered more than 1% of issued capital of the company. If an identified employee gets more than 1% of the issued capital, it has to be brought to the notice of shareholders and it should be specifically approved. The company may by special resolution once again can vary the stock option terms, provided it is not exercised. Till the employee doesn't exercise, the terms could be varied by the company. But it should not be prejudicial to the interest of the option holder. Maybe it is for the sake of operational convenience. And such variation has to be with a notice for passing of resolution of variation. It should disclose the full variations and why we are varying the terms and who are the beneficiaries of such variation. Means to issue the employee stock, you have to pass a special resolution, and even to vary the terms could be varied before an employee exercises his right, and the variation should not result in prejudice to the employee. Once again, it has to be passed by the employees by a special resolution, and that resolution should once again disclose what is the rationale behind the variation part of it. And we said between vesting and grant, there should be a minimum of 1 year. You are eligible and it vests after 1 year. Company can specify the lock-in period. Till the exercise is done and shares are acquired, there is no right to get dividend, because the only when shares are acquired, they are issued by the company for the price received, and dividend and vote will come only subsequently. This is just clarifying as to what are the rights accruing holder. Just to repeat, company has got the right to freedom to fix the price. Terms of option could be changed by special resolution with proper disclosure, but should not be prejudicial to the shareholder. And whenever the shares are issued to employee of a subsidiary, or whenever shares are issued more than 1% of the paid issued capital of the company, special approval of the shareholders is required. There should be a minimum of 1 year between grant and vesting. Company can specify the lock-in period, and till the shares are exercised and bought by the shareholder, he cannot have the right to dividend or vote. And the amount, if any, payable by the employee, if he has paid something and if he has delayed exercising beyond a specific period, the company can refund the amount if he crosses a specific period, or it can forfeit the amount depending on the situation. This is a penalty for not exercising the option within a specific period, which was one of the terms of sanction. And an employee, once he is given an option, he cannot transfer it, he cannot pledge it, he cannot alienate or encumber it in any way, or he cannot mortgage it also. It has to be by the employee or his legal representative. In the event of death, his legal heirs could use the right to exercise in respect of vested shares. In the event of resignation, he can exercise what is vested, but granted into vested into exercise. If it is not vested, it will expire. Therefore, it is granted. After 1 year, it vests, it becomes his property, but he has to buy it. Only then the share becomes his. If he fails to buy it, and if he resigns or he expires, the validity of the shares will expire and he loses in the event of resignation on termination. Therefore, once a share vests, better to wait for the right period and then exercise and acquire the shares when the company allots the shares to the people. We have just seen here now, failure to exercise, amount paid could be forfeited or refunded. Legal heirs, it cannot be transferred or pledged. Legal heirs can access it in the event of death or total incapacity, and in the event of resignation or termination of employment, shares not vested will expire. Shares vested can be converted into exercise and shares could be bought. As we said, whatever comes in the explanatory report, it has to be in the director's report also. Explanatory statement has to be summarized here, and director's report for the year will say how much option was granted, how much vested, how much exercised, how much options lapsed, what is the price that we realized, what is the number of shares issued. Is there any variation in terms which was done? How much money was realized by the company? And how many options are still in force? Employee-wise details. and the grouping of up to 5% and grouping of 1% of the issued capital, the select few which is there. The company shall maintain a register of employee stock options with the particulars of options granted, and it will be maintained at the registered office of the company. The entries in the register will be authenticated by the company secretary, and the SEBI regulations are to be followed if the company is a listed company. This is regarding the Board of Directors report and the employee stock options register, authentication, following of SEBI guidelines, and details of variation of terms if any, and employee-wise details of people belonging to the two groups of 5% and 1%. This brings us to another aspect which is known as global deposit receipts. It is issued within the country, but the GDRs are listed outside the country. This graphic presentation must help us understand the situation better. Now we have the overseas depository. Overseas depository has got a depository agreement with the Indian company, and overseas depository also have an agreement, custodian agreement, with a domestic custodian. This domestic custodian holds shares on behalf of overseas depository. It so happens overseas depository buys shares from the Indian company. When he buys shares from the Indian company, he remits through the overseas bank the money to Indian bank belonging to the Indian company, which will issue the shares. The shares will be issued and it will be kept by the domestic custodian on behalf of overseas depository. On the strength of this, overseas depository will issue GDRs to the local investors. Therefore, the overseas investors have got link only with the overseas depository, and the Indian company has got link only with the overseas depository. In the register of members of the Indian company, there will be only overseas depository which will be shown as holder of shares. Therefore, the voting rights and the dividend will move only to the overseas depository. If the overseas investor wants to be in the register of members of the company, then it has to be after the shares are transferred from overseas depository to the overseas investors, and there is a direct link with the Indian company. But so far as the GDRs are concerned, the direct link will be only between these two entities. This is the brief explanation for the way the things flow. Just to see, eligibility should be under FEMA. It is issued by the overseas depository bank. RBI guidelines are to be complied with. The board of directors have to pass a resolution. Special resolution of shareholders is required for the purpose of issuing the GDR, and a compliance report is required to be prepared by a professional merchant banker. How does it work? The depository receipts are issued by way of public offering or private placement against the issue of new shares in accordance with the conditions of RBI. The shares will be allotted in the name of the overseas depository bank. Indian company will issue the shares to the overseas bank, and the overseas bank will issue depository receipts from its end. Therefore, In India, the company issues. Outside the country, the depository bank will issue the amounts. The depository receipts will be issued in the name of the overseas bank, and therefore it will be appearing in all the registers as a shareholder. And the person who have bought these GDRs outside the country, they will enter the register of members only when they convert GDRs into shares and become members of the company. Then only they will be directly becoming the members of the company and enter the register of members. Proceeds of the issue has to come from the overseas bank into Indian bank by way of remittance. And this depository receipts issue will not be attracting the public issue regulations nor the prospectus, and the register of members will not enter the names of buyers outside. It will be in the name of the depository bank in the register of members. This is so far as non-applicability of certain provisions of the Act are concerned. We have got three more small items to be done. Allocation of capital. A company can increase, consolidate or divide its capital under section 61. But you cannot have a consolidation if it is going to change the voting percentage unless approved by a tribunal. Consolidation is subject to control. But consolidation or conversion can be done only in respect of fully paid up shares. And even when you do subdivision, the proportionate rights shall remain unaffected. And alteration also includes cancellation. If the company has lost money in terms of accumulated losses, to that extent it can cancel the shares, and that is called cancellation shares, and it will not be considered as a reduction of capital, but the process has to be followed. Increase, consolidation and divide, it should be fully paid, and the pro rata relation has to remain. And rights, if there is any change in the rights and voting percentage, approved by the tribunal. And cancellation or diminish the amount of capital can also be worked out, and it shall not be attracting the provisions of reduction of capital, but notice has to be given to the registrar for alteration. Reduction of share capital is a process. It requires special resolution to reduce the liability on any share capital not paid up, because it affects the creditors and other lenders. Confirmation of tribunal is required. It is used for cancelling the lost capital or paying off the excess. And it involves altering the memorandum for reducing the amount of share capital and its shares accordingly. But once again, to reduce capital, the company has to have sound financials. There should be no arrears of repayment of deposits or payment of interest. The tribunal, when it is applied for, will give notice to SEBI, will give notice to creditors, and a period of 3 months is given for them to respond. If no representation is received, the tribunal presumes no objection and proceeds ahead. The tribunal satisfied only when it is convinced that every creditor has been discharged or his consent is obtained, then only it will confirm the reduction of capital. And the tribunal always insists that any reduction in capital has to be in conformity with the accounting standards. A certificate to that effect from the company's auditor has to be filed with the tribunal. The order of confirmation issued by the tribunal will be published by the company in such manner as the tribunal may direct, and a certified copy of the tribunal order indicating the amount of capital, number of shares, amount of each share, amount of date of registration due to be paid upon the share is filed with the registrar within 30 days. And the registrar will issue a certificate to that effect. With that, the reduction of capital is presumed to be completed. And this reduction should not be used for buyback of shares, and no reduction should compel a person to contribute more than what he would have contributed in the normal course. Means it should not be to the disadvantage of any shareholder. And if in the list submitted to the tribunal, if any creditor's name is missed out intentionally or otherwise, the creditor can approach the tribunal and tribunal can pass orders making every member responsible to contribute to settle that creditor as if it is a settlement in the course of winding up, and they end up as contributories and the tribunal's orders will be binding on them. And there are offences listed in terms of concealment, misrepresentation, which will attract section 447, which deals with the fraud and criminal punishments in that regard. And there is a minimum penalty also for offences which are punishable. Buyback of shares. A company can buy back its own shares by making use of free reserve security premium and proceeds of the issue of any shares. We cannot use proceeds of an earlier issue to buy back now because it will be revolving in a endless cycle. The buyback has to be authorized by article and there should be a special resolution passed. The buyback could be not more than 10% of the capital and free reserves, and it should be authorized by the board by means of a resolution passed at its meeting. In a financial year, it could not exceed 25%, and the debt equity ratio should not be more than 2. The central government may notify a higher ratio. Requirement is all shares should be fully paid up, and it should be in compliance with the SEBI regulations. Between once a buyback issue is closed, for the next 1 year, there should be no further buyback. Means a gap of 1 year has to be there between one closure and opening of another buyback offer. And explanatory statement has to have the full details of the class of shares, amount to be invested, time limit of completion, etc. Every buyback has to be completed in 1 year from the date of passing the resolution. The buyback may be from existing shareholders or from the open market. It could also involve shares sold to employees under stock option scheme. And the special resolution has to be filed with the registrar before proceeding with the buyback. And in case of buyback, a declaration of solvency signed by at least 2 directors, verified by affidavit that the company is capable of meeting liabilities, and it shall not be rendered insolvent within a period of 1 year from the date of declaration. The declaration of solvency will be filed with SEBI, and where a company buys back the shares, the next step will be it has to extinguish and physically destroy the shares, a last step in the process. And once a share has bought back and cancelled, it cannot make a further issue of the same shares within a period of 6 months, except for conversion of warrants or stock option schemes or sweat equity. Company after buyback will file the particulars of buyback with the registrar of companies. For any default, there are penalties to the company as well as the officer in default. Last point is regarding, in certain circumstances, company cannot buy back. A company cannot buy back through its subsidiary, through an investment company. And a company cannot buy back when it is in default of deposit payment or interest, or redemption of debentures or dividend or term loan defaults. But if the default is remedied, it can have buyback after 3 years from the time of default. And there should be no default from the company in respect of annual return, declaration of dividend, distribution of dividend, and financial statements. In this Part C video, we have covered employee stock option, global deposit receipt, and change in capital in detail. Please refer Part A video for capital and rights and Part B video for bonus shares, sweat equity, further issue of capital, and premium and discount. Thank you so much.